Hello, Michigan Realtors, and welcome back to another installment of Letter of the Law. Today's segment will involve a timely discussion centered on the Real Estate Settlement Procedures Act, otherwise known as RESPA. Now, we continue to receive questions related to the scope of RESPA, especially how far liability under RESPA might extend. Now, this is a timely conversation because earlier this year, a Pennsylvania court was asked whether an employer could be vicariously liable for an employee's violation of the RESPA Section 8 anti-kickback rule. The case involved bank employees who had accepted kickbacks for referrals to a title company. A class action against the bank was brought on behalf of borrower customers. Now, the bank argued that it could not be liable because the kickbacks were for the benefit of the bank employees, not the bank. Specifically, the bank argued that it could not be liable because 1. The checks were made payable to the employees and not the bank. 2. The employees did not disclose the kickback arrangement to the bank. And 3. The mortgage loans were already approved and would have closed regardless of which title company was used. Now, the court refused the bank's request that it throw out the case. The court first noted that the United States Supreme Court had said that traditional vicarious liability rules ordinarily make principals or employers vicariously liable for their agents' or employees' violations of federal law. Now, the court went on to say that in each case, the question is whether the act of the employee or agent was within the scope of their authority or employment. Here, the ordering of title insurance was within the employee's job description, and the bank benefited to the extent that the performance of title insurance services was essential to the loan closings. Now, the court went on to say that an employer may be vicariously liable, even if it can be shown that the employee had disregarded the employer's instructions. Admittedly, this was a case involving an employee rather than an independent contractor. However, there are cases involving other sections of RESPA where courts have applied the same analysis in the case of principal-independent contractor relationships. For example, banks have been held vicariously liable for the actions of their servicers, which were wholly separate companies from the banks. It is quite possible that under this analysis, a court could hold a real estate brokerage firm vicariously liable for an agent's RESPA Section 8 violations. Obviously, it is very important that your agents understand the RESPA basics. Now, based on some of the questions we have received over the last few months, we think it would be a great idea to offer a refresher on some of the most misunderstood aspects of RESPA. 1. RESPA covers a salesperson's arrangements with all settlement service providers, which includes providers of all services in connection with a residential loan. That includes title services, appraisals, inspections, home warranties, and real estate brokerage services, but it is not exhaustive. 2. RESPA does not prohibit referrals, only payment for referrals. 3. There is a Section 8 exception that allows one real estate licensee to provide a referral payment to another real estate licensee. 4. Section 8 does not just prohibit cash payments in exchange for a referral. It prohibits providing anything of value in exchange for a referral. 5. Where a settlement service provider provides an actual service, for example, fills out a condition report on behalf of a home warranty company, the agent can be paid a fee, but only if it reasonably reflects the actual value of the work. 6. One settlement service provider cannot pay the expenses of another settlement service provider. For example, a title agent cannot pay for a real estate agent's advertising in the local paper. In the case of a joint advertisement, the costs should be split according to the respective portions of the advertisement. If the title company's portion of the ad is only 1/4 of the total advertisement, then it should not pay more than 1/4 of the cost. 7. An agent can own an interest in a title agency and receive a profit share calculated based upon that percentage of interest. But the agent's interest in a title company cannot be based upon past referrals or expected future referrals. An agent's percentage interest in a title company must be based upon their actual investment in the title company. 8. A brokerage cannot pay its salesperson for referrals to the broker's affiliated title company. Again, a broker cannot pay its salesperson for referrals to the broker's affiliated title company. 9. A salesperson cannot require the use of its affiliated title company. The client customer must be given an affiliated business arrangement disclosure form that makes clear that the use of this particular title company is not required. And lastly, number 10, it is still a RESPA violation even if there is no express agreement as to a per referral payment amount. For example, it would be a RESPA violation for an agent to refer their clients to a particular bank based upon an unspoken general understanding that in exchange, whenever possible, the bank will refer its REO listings to him or her. Now, keep in mind that this is just a top 10 that we developed. RESPA remains a very complex law that is often misunderstood. For a brokerage, it remains extremely important to understand the various business arrangements between settlement service providers, especially as it relates to that brokerage's affiliated licensees. Now, as usual, keep those topic suggestions coming. Your feedback absolutely informs future installments of the Letter of the Law. So please send those thoughts to the email appearing on the screen or embedded in the video description. Thanks so much for watching, and we'll see you next time.